Hello, my name's Ken Swinton, and I am a council member of the Scottish Law Agents Society. This is a talk on flooding and missives, offered as part of our CPD, which is available for free to members. This is intended for conveyancers and is approximately 30 minutes long for CPD purposes. If you want a written version of this talk, then one is available in the June 2023 edition of the Scottish Law Gazette, albeit it's slightly out of date now. This is being recorded in September 2025. So the genesis of this talk lay with comments that I saw from the past president of the Law Society of England and Wales, Lubna Shua, and she commented in September 2023 that the effects of climate change on legal practices are wide-ranging and constantly evolving. So she also goes on to say that this will have an impact on the legal advice that solicitors provide. At the time of her statement, the Law Society of England and Wales issued guidance, mostly, but not exclusively, on how legal firms can address net zero and prohibiting, for example, any greenwashing in promotional materials. However, there are pointers in relation to categories of business, and the guidance provides that of more relevance to property lawyers, extreme weather events may impact on the built and natural environment. And that was issued in April 2023. I've given you the web link there just so that you have it. At the same time, or on November 2024, Sarah Zarni, a member of the engagement and management team of the Law Society's Sustainability Committee, issued a statement on COP29. It made no direct recommendations in relation to climate change or references as to how to react to climate change. Lubna Shuha, in the article that accompanied the 2023 statement, offered some clear guidance for solicitors, and it's guidance that's issued regularly and, of course, by the indemnity insurers. Don't offer advice in areas out with your expertise, and don't seek to interpret climate change risks for clients. Now, how that squares with any change in the conveyancing process isn't clear. Where does expertise begin and end? And in September 2025, the Law Society of Scotland issued a statement saying that it was aware of what had happened south of the border and is now considering what changes might be required in relation to their guidance for conveyancing transactions. So the first point to make is nothing has happened yet in Scotland regarding any possible change in procedures. Whether the Law Society should be following practice or leading practice is a moot point, particularly as things develop. It's easy to get things wrong. So I would hope the Law Society tread cautiously in this regard. So in relation to conveyancing matters, we need to consider the Scottish Standard Clauses, version 6 of which was issued in January 2025, and in particular Clause 2, which deals with awareness of circumstances. So I'll just read you this section, or this edited selection of what's in 2.1. so far as the seller is aware, but declaring that the seller has made no inquiry or investigation into such matters. The property, including in respect of clause 2.1.3, the building, if appropriate, is not affected by. And in 2.1.2, we see, nor has been affected by flooding from any river or watercourse which has taken place within the last 5 years. Now, the clause appeared in earlier editions and appears to have been lifted almost word for word from the English form TA6, which is issued by the Law Society of England and Wales, and the 24 edition has this in clause 10.2. Now, this is a form of standard inquiries that are made and issued by the purchaser's agent to the seller's agent, and the seller's agent consults with the client and responds to those. So in many ways, it is the broad functional equivalent of the property questionnaire within the Home Report Single Survey. One of the effects of climate change is, of course, flooding. And the Scottish Government has issued advice on flooding in 2009, which was a publication issued by the Scottish Government in relation to legislation, Flood Risk Management Scotland Act 2009. And the Scottish Government has said this: flooding is a natural occurrence which can have devastating consequences on individuals, businesses and communities across Scotland. We now understand there are around 284,000 homes, businesses and services across Scotland at risk of flooding from rivers, surface water and the sea. The risk of flooding to people, communities and buildings is amongst the most severe climate risks for Scotland and is the costliest hazard for businesses. So that perhaps sets the agenda for why flooding is becoming increasingly important. Now, the Scottish Standard Clauses version 6, clause 2, relate to flooding from any river or watercourse. That means that it does not include any surface water events where there's no river or watercourse, and that means flash flooding from intense thunderstorms or intense rainstorms. Nor is coastal flooding included, and coastal flooding is a significant problem in some areas in Scotland. Sewage failures, which are the responsibility of public authorities, are also not included within the Scottish Standard Clauses provision in relation to flooding. You might ask why some types of flooding are included and not others, given the climate crisis and information which is readily available. But I would suggest it's probably in relation to buildings insurance proposal forms, where it's a frequently asked question by insurers: is the property within, say, 200 metres of a watercourse? And that then triggers further queries in the application process for buildings and contents insurance. So I mentioned already the Flood Risk Management Scotland Act 2009, which was passed in order to implement the EU Directive 2007/60/EC on the assessment and management of flood risks. The Act places a general duty on the Scottish ministers, on the Scottish Environmental Protection Agency and responsible local authorities to exercise their flood risk related functions with a view to reducing overall flooding risk. SEPA was obliged to provide a flood risk assessment for each district of Scotland using readily available sources. Thereafter, SEPA is obliged to keep those assessments under review every 6 years, and those plans and maps should be published by SEPA on their website, which is freely available. It's searchable in two ways. One, by looking at the map and zooming into a particular area, or search by postcode. And I'll say something about search by postcode and the difficulties that the implementation offered by SEPA has in relation to their statements about what is and what is not on the map. So the obligation on SEPA to use readily available sources implements the familiar BATNIC formulation, best available technique at a reasonable cost, and we can see that in the preamble to the directive. So where can we find these flood maps? The website is at map.sepa.org.uk/flood maps. So coastal flooding is not within the scope of the standard clauses, but I had a look at the centre of Broughty Ferry, an area that I am familiar with, and on the left here we can see the SEPA map without any annotations added, and on the right hand side we can see the SEPA map with the coastal flooding probability, and we see three different shades of green. Each darker shade represents increased risk. So if you're familiar with Broughty Ferry, Brook Street is the main shopping street, and Grey Street, which intersects with it at right angles, leads down to Beach Crescent. So at Beach Crescent, you might not be surprised that there is a high level of risk, but from the right-hand map, we can see that Grey Street is pretty well obliterated up to its junction with Brook Street, and Brook Street itself is also affected to the east of its junction with Grey Street. Now, that's the maps as they currently stand. Now, I chose Broughty Ferry for a particular reason, in that major works for the prevention of flooding were undertaken and completed in 2023, I think, which run right along the foreshore to prevent flooding going inland from the sea. That, however, is not reflected in the SEPA maps. So there is a warning here that SEPA's information may not have been updated because the obligation to update applies only every 6 years. So even although this is a significant risk in certain coastal areas, it doesn't fall within the ambit of Scottish Standard Clauses, and on the information that we have, it might be seen as a particular risk that people might want to be aware of, and we don't know how well that risk has been mitigated by the flood protection works that have been carried out. So there's a dilemma here. If you're aware of this information, notwithstanding there's no obligation to interpret climate change information, that's very clear. If you have that information, should you pass it on to the client to let them make their own decision based on their own inquiries? So there, I think, lies a deontological issue that might need to be addressed. Okay, that is probably enough about coastal flooding for the moment. Brechin has had a history of flooding. River Street in Brechin, which is adjacent to the banks of the South Esk, by its name suggests that there is, in fact, an issue. And there were major floods in 1957. They are shown in the left-hand picture here and were quite serious. Now, I remember as a child in the 60s driving through, or at least being driven through Brechin, and following the 1957 floods, the properties, the tenement properties on the left, became derelict. certain flood prevention works were carried out on the River South Esk on the bank there, with a new flood wall being provided. And in the 1970s, new social housing was erected, which can be seen in the right-hand picture. And we'll see that in relation to that area, in 2023, these newer houses were equally subject to flooding as the old houses had been. And it's clear that climate change was such that events that were perhaps 1 in 100 years in 1957 are now more frequent, and the protections afforded were insufficient. They were overtopped and rounded at the top end because they didn't stretch far enough upriver. So flooding can be an issue. So if one of these houses had been bought under right to buy legislation, it may well be that you could encounter a difficulty. So again, I would look at the flood maps here, the SEPA flood maps, and on this occasion I have selected the watercourse flooding maps. We have 3 colours again. The more intense each blue is, the greater the risk of flooding. And you will see from the SEPA maps, notwithstanding these works that had been carried out on the banks of the South Esk, there is a medium risk of flooding in the social housing that had been erected along River Street. And that risk becomes less further away from the river. That would be caught by Clause 2 of the Scottish Standard Clauses. In Storm Babette, a couple of years ago, the Claverhouse area of Dundee was affected by flooding. The left-hand map here shows the area, and in particular, I would draw your attention to what is Herne Rise, which is here on the map, and this on the right-hand side is the SEPA flood map. Again, we've got the 3 hues of blue, and we can see from this that the least and middling risk colours stretch right over Herne Rise. Now, the flooding may have affected some of the houses in Herne Rise, but it affected much more. It affected the whole Mansion Drive development, because the only way in and out of these 2 developments is over a road bridge here, and traffic was stopped for a couple of days from using that bridge. So it was impossible to get in or out by that road from these Claverhouse developments. And you can see the problem, and you can see the vehicle that had been hired to try and clear the water itself submerged by the sudden rise of the water. So the moral of this story is, if you bought a house in Mansion Drive, the flood risk on the property is practically zero. And yet these properties are affected by flooding. And I'll come back to that distinction a little later. So that's the Mansion Drive area there, and the bridge I've highlighted on that one. This is a surface water map, and we've got the left-hand map from SEPA showing the area. In this case, it's Orchard Grove in Edinburgh. So Orchard Grove runs off Orchard Road, which itself connects via the roundabout with Craigleith Road and Cumley Bank Road, so that if you're familiar with Edinburgh, you'll be able to locate this. Now, here, major works have been undertaken by the local authority and SEPA because of continuing surface water problems in this area here. And the road was all dug up, a large attenuation tank dug so that the drains could cope with hundreds of thousands of litres of surface water draining into the tank and then gradually being fed into the system. That, however, does nothing to assist with the Orchard Grove area outlined in green here, which is also, it would seem, severely affected. Now, I haven't shown the river course, water course maps here, but Orchard Grove is also shown coloured a fairly blue colour, a fairly deep blue colour on those as well. What I would draw your attention to here is that once again, the surface water risk in Craigleith Road has been hopefully eliminated by major works that have been carried out, but that is not yet reflected on SEPA's maps. So it just gives you a sense of the unreliability of SEPA's maps. On their website, SEPA says, we give no guarantees as to the accuracy, availability, security or completeness of the flood maps or their fitness for any purpose. SEPA will not be liable to you for any loss or damage arising under or in connection with your use, inability to use or reliance on the flood maps. How this squares with the statutory duty in the 2009 Act isn't immediately clear. The EU directive was designed to inform future planning decisions, and domestic law follows this purpose. And yet, when you want to use the website, you can search by postcode, but to go further, you've actually got to put in property address, and it covers a 50-metre radius of the property centre. So quite clearly, the information isn't just area specific, it is property specific. So that to me is something of a mismatch. The assembly of the SEPA maps was done as a desktop exercise. They used readily available sources as they were obliged to do, such as the Ordnance Survey. They supplemented that by actual records of floods reported or recorded by SEPA. But there's no duty to report, so not everything is reported. SEPA also records sewage system failure incidents. And let's not forget that SEPA was subject to a major cyber attack in December 2020. And there is a less than 100% complete confidence in that SEPA recovered all their records from before 2020. So maybe nothing appears on their records because of the cyber attack, even though things had been reported to them. Right, let's go back to the standard clauses. So the seller warrants, subject to not having made any inquiries or undertaken any surveys, that the property is not affected nor has been affected by flooding from any river course, river or water course within the previous 5 years. In the corresponding English provision, the statement is rather more restricted. Has any part of the property, whether buildings or surrounding garden or lands, ever been flooded? And it then triggers the response when. The Scottish obligations are more extensive because of the use of the word affected, and the limitation, limited warranty, so far as the seller is aware, to the best of their knowledge and belief, versus a statement of fact in England and Wales. But so far as the seller is aware to the best of their knowledge and belief, might still amount to a representation that would give rise to a claim of misrepresentation in delict. So beware of that particular clause, and have a look at one of the other talks that I've given, which is entitled Moths, but it deals with this idea of misrepresentation and that producing a remedy separate from and complementary to what's in the contract. The English provision is more wide-ranging in that it relates to flooding. So it relates to surface water flooding and coastal flooding as well, and perhaps sewers. So it's a slightly different provision. There is some fairly recent case law in relation to flooding provisions in the missives, and that is Anwar against Britain and another, reported at 2018 Sheriff Appeal Court Civil at 27, and at first instance 2018 Sheriff Court Falkirk at 31. The property in question had a small burn running through the garden grounds, and the purchasers offered subject to a satisfactory flood risk report. So it supplemented what was actually in clause 2 of the standard clauses at that time. Standard clauses relate to the property, which is the whole property and not just the buildings. Both are defined in terms of the standard clauses. So the garden ground would in fact be covered. The sellers obtained a flooding report, and this assessed the risk as low. But the report also suggested that any purchasers speak to the sellers to ask whether the property or the immediate area had been flooded. The seller's agent confirmed to the defenders that they had no experience of flooding. Following settlement, the purchasers were advised by neighbours that the burn had flooded the previous year, albeit that the property had been affected, the building itself had not been affected. Perhaps we shouldn't be surprised if there is a burn in the bottom of the garden that it might overflow its banks. They then commissioned their own professional report, which assessed the flooding risk as high, and they sought successfully to reduce the missives, the disposition and claim damages. So it's a risk that may come back to haunt the sellers. The phrase "has not been affected by flooding" didn't appear in the Scottish Standard Clauses version 2 at that time. But it was held that these words required to be implied to give effect to the wording of the clause, and in subsequent editions, such as the current 6th edition, those words now appear. Focus, in fact, turned on the entire agreement clause, and it was held and confirmed on appeal that the entire agreement clause in the standard clauses was of a type said to be a basic type of entire agreement clause, and as such was ineffective to exclude liability. It would have required a separate subclause, a non-reliance subclause, which was not present and still isn't present. Thus, the purchasers were able to rely on the assurance from the seller's agent, and here the assurance of the agent was deemed to be the assurance of the sellers themselves. And again, see my comments about other Scottish cases in the Moths presentation. So it was unnecessary in this case to consider the scope of affected, and the buildings and property issue was canvassed in Anwar against Britain. So the property could be affected, but the building might not be. It was also unsuccessfully canvassed by the defenders that the clause should be read as materially affected. It was held not to be, it was simply affected. One of the other clauses in the standard clauses is clause 24, which relates to buildings insurance. I have certain difficulties with this clause. It has a close relation in Form TA6 in England, Clause 20 in the 24 edition. What are normal and reasonable terms? Is a layperson aware of what normal and reasonable terms are? It may just flush out requirements for flood precautions imposed by the insurers, but is the fact that insurance is only available through flood ray insurers of last resort and not normal insurers really out with normal terms these days because so many properties are covered by flood ray? Nonetheless, it may just flush out some flooding risk. I'd also draw attention to clause 31.2 in version 6 of the Scottish Standard Clauses, and that relates to seller confirming that all information in the property questionnaire is true and correct, both at the time of completing the property questionnaire and at time of the offer, not down to settlement, but at time of the offer. Confirmation of an existence of state of affairs isn't a continuing warranty, but it's a statement that could be relied on if it's reasonable to rely on it, and it was relied on, then it may be that there is a claim lying separately from the contract in misrepresentation. Well, what's in the property questionnaire? Question 9, issues that may have affected your property. A, has there been any storm, flood, fire, or other structural damage to your property while you've owned it? So it's not restricted to 5 years, as in the standard clauses. It's not apparently restricted to watercourse, because there's no definition of flood in it. So surface flooding and coastal flooding would appear to be included. But anything that is affected by flood must result in structural damage. We've got to read that Eius Dem Generis. So it must be structural. So if there hasn't been any structural damage, but say the garden has flooded, then it need not be disclosed. So here we've got a mismatch between the property questionnaire and the Scottish Standard Clauses. So let's just try and sum up. The SEPA maps are prospective at best. There is limited retrospection because it depends what's been reported to them, and their own records are incomplete. There is a possibility, and I am aware of a situation where a house in the Borders, a fairly new house that had been built within the last 5 years, had in fact been built on an area of floodplain, and there was a high risk of flooding according to the SEPA maps, not just on the property, but all around the property, and affecting 2 other plots adjacent to it. The Scottish Standard Clauses are typically retrospective rather than prospective, and that suggests in the normal course any breach of warranty would give rise to a claim for damages unless it was so fundamental that it justified rescission of the contract. Searching SEPA is free and quick. The question is, should they be consulted? If you do flag it up, what do? Do you get a consultant hydrologist report at seller's expense? That seems to be what happened in the Anwar case. Consider the mismatch between the property questionnaire and the standard clauses. The former requires material damage. The standard clauses require the property to be affected. And we've seen from the Claverhouse case that affected could have a broader definition than damage to the property. I hope you found this interesting, and I would recommend looking at the knotweed and moth presentations that I've given for further insights into representations that are made by the sellers in terms of the contract. Thanks for listening. And again, if you want a written copy of this presentation, one is available in the June 2023 edition of the Scottish Law Gazette. Thank you.